Hello, welcome to BB ASMR Legal. How can I help you today? You have a case, okay. And what type of case is this? Consumer case, okay. And go ahead and describe your case for me. Okay, so you went into the mechanic, and what type of vehicle is it? Okay. Now, did you sign anything? Was there a contract, either written, digital, or verbal? Okay. Now, do you have a copy of that contract, the initial one? Okay. So if we do take on your case, I will send you a link where you will upload all relevant evidence. So that could be pictures, screenshots, contracts, anything of that nature that will help us with your case. Okay. So then you drive out of the lot and your car starts having problems. Okay. And then when was the date that this took place? Okay. So you returned it the next day. And that was the 13th. Okay. Okay. So you've already been back and forth with insurance already, because that's what the dealer, the mechanic, recommended you do. Okay. So now that insurance is involved, that's a whole nother layer to the case, yeah. Okay. Right, and it took time away from your business, your family, emotional duress, let alone the cost of the repairs. Right. And what's your work? What do you do for work? Okay. So you really need a reliable car, a reliable vehicle. Yeah. And how old are your kids? Oh, yeah, the middle school just around the corner. Yeah. Nice. So what are you looking to get out of the case? Do you want just to restore back to how you were, restore the car back to how it was? Would you like additional damages for emotional duress, punitive? Punitive meaning kind of additional damages incurred on them for their bad faith, their wrongdoing. Would you like an insurance claim? Like, what are you looking for out of the case? Okay. Yeah, you just want to be restored to how you were, right? But it was in bad faith. You believe it to be. Well, this definitely sounds like something our firm could take on. We do a lot of cases regarding vehicle problems, mechanical problems, car problems, things of that nature. So how it works is you would sign a retainer agreement with our firm, and you would pay an initial fee, which I can calculate for you, getting to know some additional information about the monetary information of the case. But you'd pay this one-time fee, and we would enter you into our system. We'd take you on as a case as a client, and that fee takes you from now all the way up to trial if necessary. However, the goal is that we can reach either a settlement agreement right away upon our demand letter. We would have to look into your contract. Are you aware if there was any arbitration, mediation clauses, anything of that nature? Okay. Yeah, we would start with negotiations, a demand for just a settlement to not take it to litigation, and most times that's what occurs. It does take it a bit to go all the way up to trial. But regardless, this first fee, paying the retainer agreement, is going to take you all the way. The only additional thing you would have to cover out of pocket are what's called hard costs. So in the event we do go to court, you would be responsible for the fees of filing, which can range sometimes up to $500, or sometimes as low as $70. It can kind of depend on what we're filing and where we're filing, things like that. So we cannot do anything further for you. We can't really give you legal advice until we get that retainer agreement fee. But like I said, once you pay that fee, we will take the case all the way, and you would just be responsible for those hard costs. Ideally, we wouldn't even need to worry about those hard costs, as we'd hope to settle it in negotiation, settlements, and potentially arbitration, mediation. That can have costs associated with it, but typically when the company has a provision, they are usually responsible for the fees of arbitration. And if it does go to trial, obviously the awards we'd ask for include attorney's fees. So you wouldn't be paying that out of cost. It would come, or out of your pocket. It would come from the damages awarded by the court. For instance, the demand letter itself, we would never charge you out of pocket for that, but that in itself racks up attorney's fees for our firm's time and effort creating the demand letter. So essentially, in that demand letter, in that settlement agreement, we say if you pursue to go further and not take our agreement, they are aware that the attorney's fees are going to go up and up and up past whatever the demand letter costs in itself. But it's very simple for you, the consumer. We don't expect you to pay out of pocket the attorney's fees. You just pay for that initial retainer agreement. So would you like me to do some calculations for you about how much that would be? Okay. So how much have you had to pay out of pocket so far for these repairs, or what are the bills looking like? Wow, okay. Yeah. Okay. And then about how much would you say you've lost in time for your business? Okay. Okay, yeah, so multiply that out, yeah. Okay. And then typically emotional duress can be a little finicky, but you can get anywhere from 1,000 to 5,000 on that, depending. But yeah, again, we really will have to look into all the evidence, the case itself. So let me put this into the calculator for you. Okay, so with all the variables into consideration, also taking into account the insurance company also being a bit involved in the case, and looking into your contract, you're not quite sure what the arbitration entails, etc., etc., it would cost you a one-time payment of $900 for us to take on this case. But like I said, that'll take you through to the end, besides any hard costs that may come up, but the goal is to avoid that. And even if the hard costs do come up, the goal would be in litigation to get those attorney's fees back. So, are you interested? Yes, we do have amazing customer reviews, as you've seen online. We are very passionate about what we do. We have very competent, qualified staff, attorneys. Our head attorney will take a look at your case himself and all of that. So you are definitely in good hands with us, and we are proud to represent the consumer. We do not want to overcharge you at all. Yes. No, I personally, from my experience, I think you have a pretty solid case. Yeah, especially with the evidence you're going to upload, that'll make it really, really strong. Okay, so I'm gonna go ahead and email you the retainer agreement. Just to confirm, are you the only name on the contract, or is your husband's, your partner's name on it as well? Just your name, okay? And could you spell your full name for me? Okay, and your email address? Okay, and a good phone number for you? And just so you know, when you do call the firm, we do have an automatic system that does record the calls and take notes. So if you're ever wary about that, just let whoever's on the phone know. We can turn that off. That's just for our own note filing, note taking purposes. But once you sign this agreement, everything, including what you've told me today, is attorney-client privilege. We will not say anything to anyone who does not have the right to know. And also, the mechanic, anyone involved, can no longer speak to you directly, and you should not speak to them directly. They will speak to us, your counsel, and we will speak to their counsel. You're really removed out of the equation as we really take it into our hands, and we really do see so much more success when you have a legal team by your side, because it is really difficult for citizens to represent themselves in court. It's just this kind of inherent disadvantage a little bit, whereas we know how to write these demand letters, these settlement agreements, all of that. Yes. Alright, and I went ahead and sent that over to you, so if you want to check your phone, read it over, any questions you have, go ahead and let me know, and then I can go ahead and take your card, put your card down for the initial $900 fee, and then once we get that and you're all signed, we will get started on that demand letter and get that out as soon as possible. Yes. Yeah, it's just a digital signature. Of course. Okay. Thank you for the card. Yeah, I'll go ahead and enter this in. And if you ever want to call us, you can. Our business hours are typically like 8 a.m. to 7 p.m. in there. I'm not get back to you as soon as possible. And then once you have that signed, I will go ahead and send you the link that you can upload all your evidence to. As soon as you can, compile all of that. Anything that you think would be relevant. This could be text messages, screenshots, pictures of the car, the initial contract, any signs of that verbal agreement you made, the insurance company. Yeah, all of that will be super, super helpful. Yes, okay, I just got your signature, so I'll go ahead and send you the evidence. Let me know if you got that. Okay, perfect. Well, we are so glad you entrusted us with your case today, and please feel free to call us. And you spoke with Bibi, and our head attorney will look at your case as soon as possible. Okay, have a great day.